USCIS approved the K-1 fiancé petition of a U.S. citizen client after issuing a notice of intent to deny it under INA 204C. In the NOID, USCIS claimed her foreign national fiancé entered a prior sham marriage to a Form I-45 green card applicant solely to gain permanent residence as a derivative beneficiary. After receiving a response to the NOID, USCIS vacated the 204C charge and approved the petition. Still, the U.S. Consulate refused the K-1 visa under 212A6C1 and instructed the applicant to file for an I-601 waiver. 10 days after receiving our motion to reconsider the inadmissibility finding, the U.S. Consulate rescinded the 6C refusal and then granted the visa. Rescission of 204C charge and 212A6C1 finding in K-1 visa case equals a true success story.
Hello and welcome to The Legal Immigrant. My name is Dyan Williams and I'm a U.S. immigration attorney at Dyan Williams Law. I can help you overcome a 204C marriage fraud bar if you can prove your prior marriage to a U.S. citizen or a permanent resident was real and not just for getting a green card. I can also help you solve a 6C1 problem through a motion to reconsider or a waiver if you qualify for this relief.
Section 204C of the INA prohibits USCIS from approving a visa petition if the beneficiary entered or conspired to enter a marriage for the purpose of evading U.S. immigration laws. If there is substantial and probative evidence of such an attempt or conspiracy in the beneficiary's file, regardless of whether the benefit was received, USCIS will deny the petition under 204C. In its notice of intent to deny the Form I-129F petition, USCIS claimed it was apparent the beneficiary entered a prior sham marriage to a green card applicant for the sole purpose of circumventing U.S. immigration laws. It determined that it was prohibited from approving the petition under 204C. The NOID marked the first opportunity to respond to the allegations of a prior sham marriage. In its earlier request for evidence, USCIS had asked only for proof of a real relationship and engagement between the couple. There was no mention of the 204C bar. The petitioner responded to the RFE on her own, and then USCIS took several months to issue the NOID on Section 204C grounds. The petitioner and beneficiary contacted Dyan Williams Law for representation in addressing the NOID. Within 30 days, I filed a timely and persuasive response to the NOID, which contained credible testimonies, objective evidence, and legal argument establishing the beneficiary and his prior spouse entered a good faith marriage, but it ended due to unresolved differences. 8 months later, USCIS issued an approval notice for the I-129F petition. They agreed there was no substantial and probative evidence to sustain the 204C finding. Because the 204C charge was vacated, we expected the visa interview to go well. But at the end of the interview, the U.S. Consulate issued a K-1 visa refusal notice citing to 6C1. The consular officer merely stated it was based on the prior marriage, even though USCIS had already resolved this issue in the applicant's favor. To find that an applicant is inadmissible or ineligible for a visa under 6C1, the consular officer must find all the following elements are met. The applicant made a false representation, the false representation was willfully made, the fact misrepresented is material, the false representation was made to a U.S. government official, such as a consular officer, and the applicant, by using fraud or misrepresentation, seeks to procure, sought to procure, or procured a benefit under U.S. immigration laws, such as a visa or admission to the United States. We discussed the option of filing a Form I-601 waiver of inadmissibility with USCIS. This would involve a long processing time and the high evidentiary burden of proving the petitioner would face extreme hardship if the beneficiary was denied admission to the U.S. Ultimately, with counsel's recommendation, they pursued another option, a motion to reconsider and rescind the 6C1 inadmissibility finding with the U.S. Consulate. We took several months to gather the necessary documentary evidence and written testimonies, including a declaration from the prior spouse confirming her marriage to the beneficiary was bona fide. In the legal argument, I also pointed out the applicant had never used fraud or willful misrepresentation of material facts in any request for U.S. immigration benefits. I also noted the 6C1 finding conflicted with USCIS's approval of the I-129F petition after it dropped the 204C charge. USCIS's approval of the petition did not necessarily mean the elements of fraud or willful misrepresentation were not met, but only that it lacked substantial and probative evidence of a prior sham marriage. Thankfully, it did not take long for the U.S. Consulate to make a positive decision. 10 days after receiving the motion to reconsider, the U.S. Consulate sent an email notice stating it removed the 6C1 bar and provided further instructions for the K-1 visa process. The applicant completed the next steps and, 3 months later, received the visa for lawful admission to the U.S. in K-1 status. Within 90 days of the K-1 visa holder's arrival in the U.S., he and his U.S. citizen fiancé married and began their life together. Less than 3 months after USCIS received the Form I-45 application, they appeared for their scheduled adjustment of status interview before USCIS. The application was readily approved on the spot, with no doubts from USCIS regarding the beneficiary's prior marriage or his existing marriage to the petitioner. The officer said they had great documentary evidence for an approval and did not ask about the NOID, the 6C1 visa refusal notice, or their relationship. It took 6 years for the applicant to receive his permanent residence from the time the I-129F petition was filed with USCIS. This long and complicated U.S. immigration journey is a true success story for the clients and Dyan Williams Law.
To request a consultation in a similar case, you may contact me by email at info@dyanwilliamslaw.com. Be sure to include a summary of your case and the reason you need counsel.
This content is general information and is for educational purposes only. It is based on current U.S. immigration laws, regulations, and policies that are subject to change. Do not consider it as legal advice for any individual case or situation. Each case is different, and even cases that seem similar can have different outcomes. The sharing or receipt of this information does not create an attorney-client relationship.